Hi, good afternoon, everyone. I'm Roma, and I work as DGM Legal with Havels. Taking it forward from where my co-panelists have addressed, I will be giving you an insight of the anti-counterfeiting strategy from an in-house perspective. And as my co-panelists have already addressed an issue that there is a difference in category of goods. There are certain goods which are luxury goods, certain goods which are day-to-day usage goods, and certain goods which are special goods. Luxury goods are the handbags, designer clothes, etc. Counterfeiting in case of luxury goods is slightly different, where most of the time consumer buys those goods by paying less, and the consumer is aware most of the time, because they're paying less for a luxury item and it would not lead to death or any fatal accident. But in special products like medicine, like my co-panelist has addressed on medicine issue, medicines, food, beverages, and electrical goods, Havells is into electrical goods, and we manufacture NCBs, circuit breakers, and wires. So these goods are basically life-saving devices. If a circuit breaker does not trip at a right time, it might lead to a short circuit. So the genuineness of these goods is very important. A consumer will never buy a counterfeit MCB, a circuit breaker, or a wire, because a consumer will be aware that in case the quality of the product is not good, it might lead to a short circuit and a fire. So the kind of policy in Havells as we adopt is a zero tolerance policy for counterfeit products, and we are very swift and we are very quick in taking these kind of actions. But at the same time, while taking an action, we do our entire investigation. We try to analyze the nature of the infringer before we choose a remedy. There are several categories of infringers. Sometimes an infringer is an unintentional infringer, and sometimes it's a squatter, a bad faith applicant, a habitual offender. Sometimes an infringer is only counterfeiting through government tenders. Sometimes an infringer is a small fly-by-night operator, and sometimes he has a very organized setup. He's even an applicant of a trademark application or a registrant. Sometimes the target that we have is from our own supply chain. And sometimes what we get as a target is only a small fish. But then by doing an entire investigation, we generally try to reach the bigger fish in the entire supply chain. We try to reach to the manufacturer so that we can target the entire chain. And sometimes the target is our own vendor. Sometimes the target is a packer, our own packer, and there is a pilferage from our own supply chain. There are cases when it is a national infringement. There are cases when there is an international infringement. So we have to choose a remedy by looking into a situation. In national cases, we have to see if the market that we are targeting is a notorious market, like a Bhagirath Palace or a Ghaffar Market or a Nehru Place. So we have to take police assistance, and we have to be cautious, keeping in mind the notorious character. And sometimes there are international countries where we're taking enforcement actions. There we have limitations of the local law, and we have to see if we have our rights registered in those countries, especially in first-to-file countries. So like I said, that every infringer is a different infringer, and we have to develop a enforcement strategy according to the character of the infringement. So we have to choose whether it is a criminal remedy or a civil remedy to be taken. Sometimes we have to see it according to the product also, the scale, size of the offender. And we see if it is an applicant, then we have to see that first of all we should file an opposition immediately just to curb his rights. Sometimes we have to file even a rectification petition against a registrant first before moving ahead with a civil or a criminal action. And of course, we always try to use customs as an important tool. In most of the countries, including India, custom is a very efficient remedy. In case there are goods being imported from China or other countries, then customs, it plays a very important role in stopping the infringing goods at the port itself. So in criminal and civil proceedings, like I said, that we take copyright actions under section 63 and 64 of Copyright Act. But at the same time, when we file those FIRs, we also try to include section 420, because we feel that the consumer is cheated in these kind of cases. As I mentioned, that in these cases, the consumer would never by choice want to buy a counterfeit product. So we try to include 420 in our complaint, but most of the time, the police authorities do not treat it as a 420 case, and the only section that is applied is 63 and 64, and which is bailable offense, because of which the infringers are very conveniently, they are released on bails, and most of them are habitual offenders. So this is one area where we are struggling right now. And of course, as my co-panelist mentioned, that if in case you go through trademark route, there is another hassle that we face of trademark opinion. So these are issues that we face in criminal thing. And I will also highlight some key points that we should keep in mind while going for a civil litigation. When we choose a civil litigation, we generally try to make our local commissioner application very exhaustive to ensure that our local commissioner raid is very effective. These things are generally ignored by most of the litigants, but I will just highlight that one should ensure that your local commissioner has a power to seize goods, raw materials, and manufacturing apparatus and dyes, etc. And your local commissioner application should also include the power to local commissioner to seize a vehicle which is carrying a counterfeit product. And the LC application should also ask for directions to police authorities. And the local commissioner should also have powers to pursue John Doe orders. Like sometimes what happens, we go for a raid action on one particular location and we do not get anything else there. So your local commissioner should be able to go to another location after getting that relevant information during the time of that action. And LC should also have the authority to take photographs and samples and to break open the lock, and directions, of course, should be given to police authorities that they give us police assistance at right time, because sometimes what happens is police authorities, on basis of court orders, they say that there is no specific order for a police assistance. So we should ensure that order is comprehensive enough to mention about police assistance, so we easily get that assistance at the time. And a day before conducting a action, one should always check if there are availability of the counterfeit products and if the shop is closed or it is open. So all those things should be prepared in advance before taking a LC action to ensure our LC action is effective. Then I'll talk about the remedies in the international area, especially keeping in mind the China scenario, because most of the counterfeit which come to India and which go to African, Middle Eastern countries, they originate from China. And China being the notorious hub of counterfeit, one should always check own rights in China, because China is a first to file country. So one should ensure that we have a trademark registration in China. And then there are some scenarios that we can take AIC action. There are raids actions which are taken with the help of administrative authorities in China. And by those actions, you can target manufacturing units. But just in case you're not able to target the manufacturing units, then these goods are also available at warehouses, where an action can be taken at warehouses also. And then from warehouses, if just in case you miss warehouse also, then these goods reach the customs for shipment. Then your custom recorder at China will help you seize those counterfeit goods at custom level. And in case that is also missed, then those goods can be seized at a destination country if you have a custom recorder in a destination country. For example, in a recent scenario where we missed a shipment in China, which was a counterfeit shipment, but we got the information of that shipment, and that shipment was destined for Kenya. So we immediately informed the Kenya customs about the details of that shipment, and the Kenya customs immediately took an action because we had registered rights in Kenya, and we could seize a shipment of huge volume of counterfeit entering Kenya. And then, of course, takedown notices are there that we can file in the e-commerce websites, which helps. Then I'll talk about other countries, how is the mechanism in other countries. In Bangladesh, of course, the legal framework is not very robust as we have in India, but there is a measure called mobile court, which is a very small court. It acts like a local commissioner. If you file an application before mobile court, it goes with you to the target and they conduct an action and they immediately there and then penalize the infringer and the matter is closed. It's a very quick remedy that we have recently tried in Bangladesh because criminal and civil remedies, they take long time and you never know by that time your infringer is in any ways, he has changed his name or something. And of course, as I mentioned, in Kenya, customs are very effective. Nepal is a tricky country because even Nepal has a first to file regime and most of the squatters, they already have registrations. So before conducting any action in Nepal, one has to see if there is someone already squatting on your right. Vietnam is also a country of first to file rights and you have to ensure that you have a registration in Vietnam. Nigeria, there is an organization called SON, which is very effective. It's an organization which registers the original goods and gives a unique identification number. So that organization is also very effective in Nigeria. And in Tanzania, custom is also very effective. Once you have targeted an infringer, of course, there are cases when you have to see settlement. So one has to be very cautious at the time of settlement and ensure that damages are awarded in all the settlements. So I'll discuss some obstacles that we generally, in our experience, face. Sometimes the lead which is generated, it is a bogus lead. And sometimes our agent is also, the integrity of the agent is questionable. So we have to ensure that the agent that we are using, he himself you have checked his integrity. And sometimes there is police inaction due to unexpected hurdles. Like there is a VIP movement and you have already filed a complaint and the target is ready, everything is ready. But police authority will tell you that today there is a VIP movement, I cannot go. Because of course there are other priorities. And sometimes due to festival season, police cannot take action because the market area is decorated and there are a lot of other civilians. They don't want to take action during the festival season. Sometimes the shop is closed. Sometimes there is a market association pressure, especially in markets like Nehru Place and Bhagrat Place, when you conduct a raid and the entire market, everybody comes around you and they surround you and they create a pressure that no, they are original, and these people generally mix counterfeit goods and original goods and they try to show you invoices which are of original goods and they say that the seizure is wrong. So sometimes local laws, as I mentioned, is always a challenge in international jurisdictions. And then I'll discuss another area which is of a concern these days. That is e-commerce, and in most of the cases, one scenario is a fake website. Sometimes infringer, they create a website which is entirely fake and they imitate your website, they use your trademark and create a domain name. So that is a different category of counterfeiting by using e-commerce. In those cases, you have different remedies. You can go to UDRP and file a complaint. You can request the payment facility to be withdrawn. Then you can file a takedown notice also. And you can also request for turn off of access to the website. Another scenario is e-marketplace. As my co-panelists have spoken, that marketplaces are a nuisance for everyone. Like it's a very simple argument that marketplace comes up with, that they are just the intermediaries. But recently there are judicial trends in India which are very, very progressive, especially a case which was recently decided by Delhi High Court in a suit called Christian Louboutin versus Nakul Bajaj, wherein Delhi High Court has laid down some more guidelines, wherein the Delhi High Court had said that e-commerce platform cannot claim to be an intermediary if it has played an active role in enabling the violation of intellectual property rights. And e-commerce platforms cannot wiggle away from their liability as infringers or as enablers of infringed goods. Now, since the Delhi High Court and most of the other courts are passing favorable judgments, like the judgments have just been discussed by my co-panelist of Skechers goods, Lacoste, all these judgments are in which the courts are awarding damages also of high value. So there is an atmosphere where brand owner is feeling secure and brand owner is feeling that there is something going to happen. But at the same time, there are internal strategies which brand owners are following. So the way forward, which I feel we should have as a brand owner, is that we should have a regular surveillance. We should use association and industry level efforts to sensitize police. We should keep a regular watch on internet, and we should keep raw material and component packing suppliers sensitized, and we should use technological tools regularly. Thank you.